This is Starting Point, a podcast that tracks Guyana's unprecedented growth from all vantage points. Join your hosts, Kiana Wilberg and Fariza Hanif, as they dive deep into the heart of topical issues.
Welcome to this week's episode of Starting Point, the Oil and Gas Edition. I am your host, Kiana Wilberg, and today we place the spotlight on the legislative agenda that underpins the unprecedented growth that has been enveloping Guyana in recent times. Sitting at the helm of this legislative transformation is Guyana's Attorney General and Minister of Legal Affairs, Mr. Anil Nandlall, SC. Attorney General, welcome to our podcast.
Thank you very much, and good afternoon, good evening, good morning to your listeners and viewers.
Now, Minister Nandlall, I want the starting point of our discussion to be on a reflective note. You come from the 1970s period where Guyana had its first president, Arthur Chung, and now that you reflect on the period through which you grew up and where Guyana finds itself, what's your perspective on where we stand?
Well, my view on this issue has been articulated on numerous occasions, especially during the elections period that we just concluded. And I said to every audience that I've had the opportunity to speak to on this matter that this generation of Guyanese is the most fortunate and blessed generation to have ever lived. Everything that our foreparents dreamt of, that they struggled for, that they toiled for, that they died for, we are able to see and be part of it becoming a reality. Mm-hmm. You know, those of us who were fortunate to be able to travel overseas in the 80s and 90s and in earlier periods of our lives would go overseas and you look at buildings, you look at infrastructures, you look at clothing, you look at restaurants, you look at many, many facilities, and you almost take for granted that these things will never happen in your lifetime in Guyana. And you take for granted that these things can only happen overseas, that you will never enjoy these facilities in your homeland, so you have to enjoy it elsewhere. And then you look around you now, and I've done it many, many times, and you see that even finer facilities, better facilities that you may have been looking at in the past in foreign lands are here now. And I could identify many places, but just take the Demerara Harbor Bridge. No Guyanese, if they would want to be honest, 20 years ago or even 10 years ago, could have predicted accurately or could have foreseen accurately that we would have had a bridge of such majesty, such magnificence, such magnitude built in Guyana in our lifetime across the Demerara River. And that's just one example of what I'm speaking about. So we have traveled a long way. We have achieved what was thought to be unachievable. You go into some shopping centers now in Guyana, and if somebody blindfolds you and take you there and tell you that you in another capital, you wouldn't know, you know. So I am elated more than elated to have witnessed what I am witnessing in Guyana, but even most importantly, to have been offered an opportunity to play a role, as minimal as it may have been, or as it is, in bringing a lot of this, what we are seeing, into fruition. It is a blessing indeed to be part of this process and to be able to contribute. And from everything that we are seeing, we are now entering the transformation age. I spoke of bridges. We have a feasibility study now being concluded on a Berbice bridge across the Berbice River. You saw movements taking place in concluding arrangements for a bridge across the Quarantine River, bridging Guyana with Suriname. You look at the airport, and every time you go to the airport, you see another important and significant addition being made to it. So the transformation is evolving before our eyes, infrastructurally and at the policy level, and in fact across every facet of life in this country. And to use an overused word, the transformation is unprecedented. And that's why we have become arguably the most attractive investment destination in the world. Take, for example, just this minor accomplishment. We have been pursuing the establishment of a council's 4th law school in Guyana for 35 years. The first president to have put that on the agenda of CARICOM was President Dr. Cherry Jagan. Look how many presidents have since passed, and we have been unable, over all those years, 3 and more decades, to have secured the permission of the relevant authority, which is the Council of Legal Education of the West Indies, to proceed with this project. We got it in September, after 2 or 3 years of intense work by our government. That is another monumental accomplishment. And I can go on to talk about, accomplishment by accomplishment that we thought we would never be able to achieve. And as I'm on the hospitality sector, for decades, my parents and your parents grew up in Guyana knowing that Guyana only had 2 hotels of worth: the Pegasus and Tower Hotel. Those were the only 2 hotels of note that one could have pointed to in Guyana. And generations resigned themselves to the reality that those were the only 2 hotels we will ever have of worth in the country. Today, we have Marriott's, we have Holiday Inn, we have Hilton under construction, we have, I think, about 10 branded hotels that are in the making. You tell somebody that 10 years ago, that in 10 years' time, Guyana will have 10 branded 5-star hotels, and they will tell you that you're crazy. But we are living that reality. And as I said, this is only the beginning of the transformation. For generations, many persons lived in Guyana almost transiently. They lived until the papers were processed so that they can join their relatives and families overseas, or until they achieved some professional qualifications that would have allowed them to self-sponsor to some other jurisdiction, where they put their lives on hold until these eventualities take place. And then they move on. And then they begin to live when they go to these countries. That is not so anymore. You have a country where the people have hope. They have optimism. They see a future for their country. They see a future for themselves. And most importantly, they see a future for their children. 90% of the families who even decided to live in Guyana, even those who decided to live, which would have been a small few who would have been doing well, if they are going to be honest, they will tell you that while they had decided, or they decided they will live in Guyana, they put into place all the preparations for their children to migrate, because they did not want their children to live in what they would have considered a backward, underdeveloped, poverty-stricken country. Today, that is not so. You look at Guyana and you can feel a sense of assuredness that your children have a future here. You don't have to make arrangements for them to go and permanently live. Of course, you make arrangements for them to study, and that's normal. Third world countries and countries in our geographic space, they go to study, or the children go to study in the metropolitan areas, and they come back. And that's the position now. Guyanese are coming back. The children are going to school in Guyana. They are staying in Guyana. Those who decide to go and study, they come back. It's not where 99% of the time they go, they never come back. And those things are intangible things. It's not a highway to which one can point. It's not a bridge that I can highlight. It's not a Marriott or a Hyatt or a Holiday Inn that I can point to.
A very important
But
nuance, though.
it's the hope of a people. It's the optimism of a people. It's the mental and psychological security of a people. And that you can't put money on. It's incomparable. And that's what we have been able to achieve. And that, I believe, along with every other physical accomplishment, forms an indisputable regime of achievements that we have never witnessed before. And that's why I began by saying that we are indeed the most blessed generation of Guyanese to have ever lived.
Minister Nandlall, I want to touch a bit or drill down a bit on what you noted earlier about the role that you play in all of this, in the times in which we're living in. And as you noted, it's truly unprecedented, an overused word, but still very much important in its meaning, very apt in its use. The times that we're living in, the extent to which business is being done, it's truly at a completely different pace, a different level. And so legislative reforms have been crucial to creating the environment that is necessary to support this type of growth. Share with us some insights on some of the notable achievements, the headway that you've made at your ministry regarding the support that is required for the level of development and growth we're seeing today.
From a legislative perspective. So I've often said that, well, I don't want to say I have often said. The reality is that you hardly can find a major policy imperative that can be implemented and successfully executed without a regulatory framework. And that regulatory framework is invariably a legislation that will govern the particular concept. And you can choose at random. let's take something that people don't normally associate law with. Medicine. We wanted to modernize our medical care program and to embrace and envelop it in it modern medical procedures. But those who wanted to promulgate that concept quickly realized that you can't do it without legislation. So we had to pass a suite of legislation, like the tissue transplant legislation, and a number of other legislation to make just those medical procedures possible. We had to enact data protection legislation because you need to take people's personal data, their medical history. Once you take that, you have to find a mechanism to store it and to protect it and to guard its confidentiality and to only access it for defined legal reasons. How are you going to do that? You have to have a legislation that sets up a framework that facilitates the attainment of those objectives. Telemedicine, we wanted to do that, or we are doing that. We had to get telemedicine legislation in place. And that's just in the medical field. I move across to housing, another area that one would not think has any connection with the law other than a basic connection that you must act lawfully, etc. So we wanted to modernize the housing sector, diversify the housing sector, import into the housing sector concepts that we see have done well in more advanced countries. For example, a condominium. When we look at the laws in Guyana, it did not permit the establishment of condominiums because our land titling system gave you a title or a transport, if you wish, for a plot of land with that building that is on the land. So if you have a building with 20 apartments, you only have one transport or one certificate of title for that plot of land upon which that building with 20 apartments stands. But condominium allows each unit in that building to be owned separately and apart from the building itself. But our laws did not permit that. So we had to enact a Condominium Act. Where we had to specifically put in the law how you can extract out of a whole a unit, and a person can own that unit with a title, or buy a title, or buy a transport. We had to put a Condominium Act into force. We wanted to do a very modern and efficient mechanism to process building permissions. If you want to build a building, you have to get like 50 different pieces of papers, pieces of permissions, which have to be approved by multiple agencies. And historically, this process of obtaining these different permissions have proven to be a nightmare. It's a bureaucratic process, it's riddled with red tapes, and overwhelmed by corruption. So you got to pay a bribe at every stage of the way, right? That has been the experience of people. I know it because I build. So you have to get city council to approve a plan. Then you have to get fire. That plan has to go to different places, including central housing and planning. That alone takes up an inordinate period of time. Then you have to get fire permission. Then you have to get public health, sanitary certificates, public health approvals. Sometimes you have to get EPA approvals. And depending on the nature of what you're going to do, you have to get an additional menu of approvals. We realize that we can't continue in this path that if we want to push the developmental agenda of this country, we have to think outside of the box. We have to be innovative. And you don't have to invent the wheel. You look around the world, and there invariably you will find a model extant and being used successfully in another country. All you got to do is borrow that concept, adjust it to meet your local circumstance, and you run with it. So we said we will use a single window where the applicant for these licenses, these permissions, go to a single window, deposit everything there, and then a machinery takes it to the various agencies and gets the approval. And if there is any deficiency at any stage, the applicant is written to and given an opportunity to correct the deficiency. And importantly, if at some link in the chain or at some stage of the process, one of the agencies dilate on the matter and a period of time passes, we say that the applicant must not suffer, that whatever permission was being applied for or sought from that agency, it would automatically be granted by their default. That has never been done in this country. Now, where do you put all of this thing? This thing that I just outlined to you, where do you put it? You have to put it in a law, in legislation. So we have a Single Window Transaction Act. We want to use electronic signature. We want to move from manual paper contracts to electronic contracts, to e-contracts. The world has gone in that direction. How do you do that? You have to pass a legislation to that effect, a law to that effect, and create the environment and list the steps and put the consequences that will flow if there's a violation of any one of these rules. That is what a law is. So every one of these major policy concepts and imperatives, you need, that's the baby, and you need a cradle in which the baby has to be nurtured and weaned into adulthood. That cradle is the legislative framework. And that is the role of the Attorney General, or one of the roles of the Attorney General in the developmental agenda, trajectory, and developmental path that we are traveling.
So
and that's why we have such an aggressive legislative agenda, because we have an aggressive developmental agenda. And the legislation is the skeleton. Your policy is the flesh. It's the two that makes up the complete human being. Right?
So quite a lot has been done in the last 5 years, and I'm sure that that's just the tip of the iceberg. But I want to move to another very important matter within the business landscape, and that has to do with the banking sector. Now, I know you recently met with stakeholders within this industry, and I want to get, for the benefit of our audience, have you been able to discuss what will be the way forward regarding, as you said, the red tape and the arduous nature of setting up a bank account in this country?
All right, so I hope you have enough time on this program. You know.
Yes, you do.
So we are passing all these legislation. And we have a policy as a government that we don't proceed to legislate without consulting, in particular, the important stakeholders relevant to that legislation. So if we are going to enact something about the banking sector, or in which the banking sector is going to be a main stakeholder, we engage the banking sector, we engage the private sector, we engage the Georgetown Chamber of Commerce, we engage other important stakeholders. If we're going to do something of a significant nature that will affect law and the administration of justice in the country, we consult with the judiciary, we consult with the Guyana Bar Association, We consult with other associations representing lawyers. We consult with human rights organizations and so on. So we consult, that's the first thing. But the pace at which we are moving and the complexity of some of the legislation that we are promulgating require ongoing engagements. And I believe that we have faltered in the ongoing legislation. And I personally may be guilty because, you know, after you consult and you get a firm buy-in from the stakeholders and you take the bill to Parliament and it becomes law, I then proceed on the assumption that there would be smooth implementation. And that if there is not smooth implementation, at least a quick resort would be had to me or the sector minister whose legislation it is. Because not everything falls under the Attorney General. Like the Condominium Act, the sector minister is my brother, the distinguished Colin Crowe, right? Everybody sometimes, when things go right, you don't hear anything. But when things go wrong, they go say the Attorney General. Well, they are sector ministers. I'm not blaming anybody. But the point is that I assume that, once the thing is passed, these main institutions such as banks and insurance companies and major players in the commercial sectors, I know that they have competent lawyers and competent batteries of lawyers. And I assume that, they would have the lawyers go through. But the reality is that is not happening. So in my recent engagement, I learned that. And my engagement flowed with an engagement that the banking sector had with His Excellency the President, when they flagged a number of issues, and the President immediately engaged me and said, sit down with the banking sector, sit down with this important stakeholder, and go through whatever problem they have, and let's see how we can address it. And I met with them immediately, the very next day. And as it turned out, there were no major problems. It's just a disconnect. The legislation is there. We were told that the regulations were not enforced, and that is not so. Everything was in place. It's just that we need to engage more, and so that if there is misunderstanding or a lack of clarity on any of the provisions of the statutes, whatever they are, we have to discuss them. And that was what was really lacking. There was a particular piece of legislation that we had to bring something into operation. And we agreed after discussion that it would be up and running Tuesday. So one meeting clarified what was described as a huge number of issues. Just one meeting. And it was just clarifications. There was no hurdle that, was of any substantial nature. It's just a lack of clarity and a lack of just simple engagement.
Could you say what is it that has to be activated?
Like, for example, so that brings me to the question. This was a backdrop to the question. So you're asking me what mechanism in place we have put in place to allow for easy access to finance.
The easy setting up of accounts.
Oh, accounts, okay. All right. Now that's a very crucial question because that came up as well. So, Kiana, you would recall when we were a minority government between 2011 to 2015, the APNU AFC enjoyed a one-seat majority in the National Assembly while they were in opposition. And they withheld their support from a number of crucial pieces of amendments that Guyana was required to pass to improve and enhance our anti-money laundering and anti-money laundering, countering the financing of terrorism framework. So you will recall that we took several bills to the National Assembly to amend our AML-CFT Act, to implement international recommendations that came from the Financial Action Task Force, that the entire Caribbean was required to enact. But our parliament, because of this one-seat majority enjoyed by the opposition, voted them down one after the other. And for 3 years we had this struggle. You had the CFATF, Caribbean Financial Action Task Force, people coming down here. You had CARICOM leaders issuing statements calling upon the opposition to support the amendments. You had President Ramotar and the government pleading. You had private sector making public statements. The manufacturing sector, the whole country was up in arms. But the joint opposition maintained their non-support for these measures. As a result, as we expected, Guyana was sanctioned because we did not meet our international obligations. We did not satisfy the international tests. So when you're sanctioned as a non-compliant state with the international legislative framework regarding AML-CFT. Once that happens, consequences flow. Your financial system becomes blacklisted internationally. You lose corresponding relationship with banks. People can't send money to your country unless they go through a rigorous regime of source of funds, etc., etc. So a menu of sanctions. If you go to open a bank, the banks now come under pressure. And they now have to implement a strict regime, right? Now, when they got into government, they passed a lot of what they voted down. And then they did something else. So Guyana was able to come out from that hole that it was in, right? And then they did something else which perhaps we are not talking about. Now, when you get these recommendations from CFATF, the Caribbean Financial Action Task Force, and they in turn get it from the Financial Action Task Force, the world body, and this is the regional representative. They come in the form of recommendations. Now you have to look at those recommendations and adjust them to meet the peculiar circumstances of your country. Some of these recommendations, they come at the optimum level. This is the 100% requirement. But if you are to implement that wholesale, you can possibly shut down your economy because you're setting standards that are too onerous. You're cutting your own legs off. So you have to prudently examine it, look at your fiscal and financial structures, and adjust that, modify it to make it compliant, of course, but more importantly, conducive to your local circumstance. My predecessor accepted these things wholesale and implement them. Right? So you have what we enjoyed, what we endured after that was a double whammy. Not only did they not dismantle the oppressive sanctions that were imposed, right? When we were put on this gray list, when we were sanctioned, where although we came out of it, they never dismantled the oppressive guidelines and that regime that would have been applicable only during that blacklisted period. They kept it. And then to make matters worse, they brought in the new recommendations, those that were, because it's a constant thing, you get recommendations at periodic intervals. They brought in those, they never adjusted them, they implemented them wholesale, word for word. So they made the environment extremely oppressive from an AML CFT standpoint. You follow me?
Yes.
That is why, for that, one of the reasons why the economy contracted so much during that period was because of this. And as I said, I don't think we ever spoke about this in an expansive way. When we got into government in 2020, one of the first things that I started to do was to prepare a series of amendments. Because when we were in opposition, these amendments had to have been passed in the parliament. And I remember me in particular and our entire team in the opposition, because we were in the opposition, we opposed every one of those amendments, not because we were opposing to them in principle, but we were opposing them in the manner in which they were coming. We said from the beginning we support all Guyana's obligations, whatever they are. We support Guyana complying with them. But we pointed out the dangers of not adjusting these recommendations, because I was looking at the recommendations as they came, and I'm seeing that the exact thing is in the bill. And I know that we don't need that 100% compliance. 60% of that would not have changed the situation, but would have made it far less onerous for our financial sector. So we did all those adjustments when we got into government. A series, I think about 3 sets we did. And while at the same time we are implementing new ones. But again, I think that we are not engaging, and this is why. A lot of what is still in the banking sector are remnants of that outdated regime. The period when we were sanctioned and the period during which the APNU AFC imposed. Then is when remember the bank were under pressure. The banks themselves did guidelines. The central bank did guidelines for the banks to follow. And in my humble and respectful view, I don't think that there was ever a comprehensive review after we did all the readjustments when we came in. And that is why we scored, and that's what I was telling the bank the other day, we scored the highest at the last mutual evaluation exercise of the Caribbean Financial Action Task Force in terms of independent Caribbean territories. 2 countries got higher scores than us, and there are 2 dependent territories. I think one is Anguilla, and one is, I think, the U.S. Virgin Islands or something like that. One is a British protectorate, and one is a U.S. Dependent territory. But among the independent Caribbean states, we did better than all of them. So how, on what basis are you telling me that it is easier to open a bank account in one of those countries when they have problems, in Trinidad or Barbados, than Guyana, when our system was certified to be far more compliant than theirs? It means that our system needs to do an introspection and rid itself of self-imposed obstacles that are no longer relevant. No longer relevant. Look, only the other day, Jamaica, Barbados, and Trinidad came out of a review process that they were in, meaning that they had serious problems. Only the other day they came out and they had to hire international experts to guide them through this process. And yet I am told that to open an account in one of those countries is less burdensome. That
it is.
something is wrong. So, as I said, we need to engage again with the banking sector. Anyhow, I don't want to say it, but I know what I think I have a feeling of what some of the problems are, and they are simple problems to address.
So,
And
what
I
I'm
hope
getting-
that in my continuous engagement, because the president said, rightfully so, continue to engage
So-
until we find this, well, continue to engage because it's a constant process anyhow, on all different matters. So we plan to do that, government and all the important stakeholders. We have always engaged. We always have a track record of engagement. What it means now is that we have to intensify those engagements.
So it's safe to say that one of the issues on the agenda in engaging the banking sector is to remove the obstacles that you provided that background, that historical
Yes.
context to,
It-
so that there is a greater ease of doing business.
That's correct. The president started that process. When he was Minister of Trade and Tourism, the ease of doing business initiative was implemented by him in that ministry. And our government has never moved away from it. So he understands this concept very much. And when he started the engagements with the bank just after we returned to government, after September, that's how the engagements began. We have to dismantle whatever these onerous strictures are in the banking sector so that ordinary Guyanese can have easy access to the banks. And we are encouraging Guyanese to engage with the banks more often. We want to move Guyanese away from putting money under your mattress and putting it in some tin cup somewhere. Let us use the banking sector. And we are able to get them to engage with the banks by initiatives such as the cash grant distribution. You pay by check, they have to go to the bank. Or we are hoping that they go to the bank. So you begin to get that engagement going. That is how you have to move the country. You have to move the country into this modern age.
As we talk about moving the country into this modern age, one of the priorities of the business community, especially with the influx of opportunities we see from the oil and gas industry, is the concern about access to capital. Now, we've seen one bank in particular, GBTI, step up to the plate to say, okay, we will flex a little bit and introduce invoice financing, where you accept the invoice as a means of access to capital, access to loans. But this is a sort of a voluntary process. Are you contemplating from your end any regulation or policy that helps this to become the norm?
So we have had this issue on the agenda for a while now. At some point in time, it was thought that before financing can be granted by the banks, one must have collateral security of an immovable kind. I researched the matter, and there is no such requirement in our laws. None. Right? So that was the first hurdle put up when we asked that invoices and agreements of supply, whether it's goods or services, be used as a form of collateral. We were told by the banks, no, there is something in the law that says that only immovable property can be used. I knew that that was not right, because from time immemorial, banks have been lending monies to purchase motor cars, for example. And the motor cars is the security. The motor car is not an immovable property. So how you can lend money on a wheel and deal, isn't that what they call it? Wheel and deal. How you lend money on a wheel and deal platform, for want of a better word, to purchase motorcycle or motor vehicles, and you don't ask for immovable property as security. But then when a motor car is, let's say, $3-4 million, somebody produces $100 million contract. The contract guarantees supply of $100 million. But you don't want to lend on that. But you're lending on a $2 million. And your excuse is that there's some requirement of a immovable property. And that's not so, because you're lending on the car and there's no house is being lodged as security.
So that's been an artificial barrier for years.
That's correct. So when we researched it, I couldn't find, let me put it that way, I couldn't find any provision in the law. If there is one, I didn't find it. But I'm giving you a practical demonstration how the banks, despite the alleged existence of this prohibition, have been lending money to finance the purchase of movables and using that movable as the collateral. So, in my view, and I met with the banks, the banking sector or the representatives, and I said to them what my view is, and it's a question of risk. Who wants to take the risk? That is what it is. One bank has come forward and is taking the risk. And I have no doubt that other banks will follow, because we live in a very competitive society. And the business sector is a very competitive sector. Everything is about risk, right? No pain, no gain. You don't take a risk, you will not be exposed to the benefits that may flow. You don't buy a ticket, you cannot win the lotto. So once one bank goes out there and offers that service, market forces, I think, will demand other banks to come forward. But the government's position has always been, whatever legislative support is required to ensure easy access to financing, we remain ready, able, and willing to supply that support. We are not ambiguous in our commitment in that regard. But let us know what the specific request is. What is it that you want us to do? And we will do it, because we are supportive of a vibrant commercial environment. We want this economy to grow faster than it is growing. We want Guyana to continue to be the attractive investment destination that it is, both for foreign and local investment. And our government is there to ensure that that atmosphere is created and that environment is created that will conduce to these investments taking place. And whatever we can do, we are going to do.
Now, Minister Nandlall, with the influx of commercial activity we've seen over the past 5 years, there has also been, and understandably so, an increase in commercial disputes. And I want to ask you to address sort of a Twin Tower issue. There have been concerns about, one, cases that may involve the determination of jurisdiction of the courts. And I want to, on that leg, I want to ask, what is your advice to the business community to ensure that our courts, for operations that they engage in here, that our courts are made to have the jurisdiction over any sort of dispute that may arise? And then the other tower of this issue is the extent of the reach of judgments. Say, for example, I have sued Company A for monies outstanding to me, and Company A packs up and goes to America, and it has its headquarters there. How do I guarantee? What guarantees do I have that the judgment handed down in my favor will be enforced no matter where this person runs, where the company runs?
All right. So, and I want to add a forest tower to the two that you have put up there. And the forest tower is to assure your audience and your viewers that we have a modern and effective infrastructure and apparatus in place for the efficient settlement of disputes in Guyana. So I want to make that clear. We have our judiciary that we have worked extensively on, and we have resourced tremendously over the past 5 years in particular, and even before. I think our worst critic will tell you that the judiciary has never been as resourced as it is now, ever before in its history. So that's the first thing. Secondly, we have put into place, along with the judiciary, because they're independent. When I say we, I mean
Yes.
Guyana. We now have specialized courts that deal with specialized type of cases. So we have had a commercial court for more than a decade now, and it has worked. So commercial matters don't go to any judge. It goes to the commercial court, and it is heard in an expedited environment created by that court. That's the first thing. In terms of disputes with the government, constitutional and public law matters, we have a constitutional and public law court that deals specifically with those matters. And all these cases that you see the Attorney General appearing in, including the political cases, they're all filed in that court. And again, our worst critic will have to concede that those cases are being disposed of with commendable alacrity, right? So the backlog that has burdened our judiciary for decades due to dedicated and innovative initiatives, due to injection of a lot of resources, due to hard work from our judges, we have managed to successfully reduce that backlog to the extent where it hardly exists, at least in the High Court. We have a backlog now with the Court of Appeal, and that is being addressed. We have in our system now more judges than we have ever had. Currently, I believe we have about 14 in the High Court. We have never had 14 judges in the High Court before. We have 11 in the court, 10 in the Court of Appeal, and I think 11 now in the Court of Appeal. A full complement. 2 are to be sworn to make it 11. We used to have 3 judges in the Court of Appeal.
Yes.
The full complement, I think, was 5. We now amend the law to put 11. So you have access to the courts, and you have a court that is equipped to move efficiently. And of course, we have the Caribbean Court of Justice. So if people think that the courts below are not competent or not efficient, or for whatever reason they don't trust the integrity of the system in Guyana, you have the Caribbean Court of Justice, where the matters will eventually go. So that's the first thing. That's my tower, right? Let's come to your tower now. jurisdiction, because you have many, and it's a very good question you've asked. I haven't sat down with somebody asking me questions for a while. I speak by myself on issues in the news. So I got to do this more often. So there is a whole body of law called private international law, that contains the principles that will determine which court has jurisdiction over matters.
Okay.
Most times, the general rule is, the general principles are, the place where the activity or the major part of the activity that is the subject of the agreement, where that activity takes place or where those activities takes place, that is where the contract, that is the place where jurisdiction will be founded.
Okay.
Also, where the contract is executed, where it is signed, that also is a factor that will determine where the contract is, where the jurisdiction will lie if there is a dispute, right? So the issues are not unclear anymore. And most contracts, they are executed in the place, when I say executed, they are signed. That's a form of execution. In the jurisdiction where they are to be performed. So where the contractual activity will take place, that is normally where the contract is signed. And that is a place that will have jurisdiction. Of course, parties are free to agree to have their dispute settled elsewhere, right? And that is normally a clause in the contract, and in accordance with the laws of a different state. Nothing is wrong with that. That's freedom to contract, and that is the sacrosanct nature of the party's freedom to contract. And I don't think any sensible government would want to circumscribe that. What we can do and what we have been doing is to examine why you want to go to another country. Because we want you to settle your dispute here.
Right.
Now, we have done that inquiry. And one of the main things that have been identified as the reason why they want to export the resolution of their dispute to another place is because we don't have a modern arbitration framework. As a result of that, the Attorney General Chambers embarked upon a course to find the most modern expression of arbitration law in the world. And we did so. We did not do so alone. As part of the government of Guyana, we engaged a law firm from the United States that has over 1,000 lawyers and has a huge arbitration practice. We engaged another firm from the United Kingdom, and we brought these people down. They examined our legislation. We had workshops with them. I engaged experts from the Caribbean. We looked at a Caribbean model legislation. We incorporated the United Nations rules on arbitration. And we concluded an arbitration act that I will, without modesty, boastfully say is one of the most modern pieces of legislation of its type in this part of the world. It allows for foreigners to come in and set up arbitration centers here. It allows for the government to set up an arbitration center. It allows for the judiciary to set up arbitration center. So there are organizations in the world that offer arbitration services in the arbitration capitals of the world. In Hong Kong, in Paris, and I just came from one in Paris, in London, in Washington, in Singapore. Those service providers, the act is so constructed that it allows them to come in. So we don't have that you must be qualified in accordance with Guyana law and that type of thing. Whatever your international qualifications are, you're going to be able to practice as an arbitrator here. And you're going to be able to set up your own arbitration center if you wish to provide that service here. And of course, we have a modern legislation that allows for parties to settle their arbitration, their disputes by arbitration in the same way that they can do it in London, they can do it in wherever. Because once you have the legislation and the framework, arbitration can come in, be done in the studio. The arbitrators are the persons who are going to listen to the arbitration, and those who, and everybody can come from London, they can come from Paris, they can come from Sweden, Brussels, wherever. Once you have the framework that is as modern as one of those capitals, then 90% of your work is completed. And we have put that in place in Guyana. So no one can say that we don't have a modern arbitration framework. And our arbitration can be done without any resort to the court. So let us say you have big investors and they don't think that our judiciary has the capacity or the efficiency or the integrity to hear and determine these disputes. Well, we have an arbitration act that insulates the judiciary from the process. You can just say that you want your dispute to be settled in accordance with arbitration, and our act gives you the most modern facilities available in the world in relation to arbitration resolution of disputes. Right? So you don't have that problem. So let me get to your second tower now, which is the enforcement of judgments. So no country is an island. The world is a very integrated place. So it doesn't take a brain surgeon to figure that you must have a mechanism in place internationally that allows judgments validly and obtained in a court of competent jurisdiction in country A to be able to be enforced in country B. And you must have a reciprocal type of arrangement in place between these two countries because they are sovereign nations, right? So you got to buy in agreements. And this has been done since we were a colony. You had an old Foreign Judgment Reciprocal Enforcement Act dating back to 1920s, signed between Great Britain and many other countries. And at that time we would have been a colony, so we would have received that law. So all the countries that were signatory with England to have English judgments obtained in English courts enforced in those countries, Guyana inherited that. It was a list, at that time it was confined to Commonwealth countries only because Britain was ruling about 50 odd countries at the time. So we had about that arrangement in place. But that was an old act, nearly about 50 years old. It was about 100 years old, but it was amended about 50 years ago. The schedule was amended in terms of to which countries it applies. We repealed that act in 2023, and we passed a modern Enforcement of Foreign Judgment Act. And as I said, it's a model legislation. I believe I got it from CARICOM. And we included in the schedule of countries about nearly 150 countries. So Guyanese judgments can be enforced in about 150 countries.
I think that's a very important point,
Right?
because it inspires confidence
Yes.
in the business community too.
And that is why it was done. Because investor A can come here, run up a liability, have very limited or no asset in Guyana, pack up shop, and disappears to Australia. Well, we have that agreement with Australia, and we can enforce in Australia. There are countries on that list that we may have to have agreement with, and that is something that we'll begin to work on. Like, we never had these types of relationship with a country like China, because we come from a different legal system. So and you add countries there that we never had relationship, that type of relationship with. So we have to get those concluded. But the legislation is there, the framework is there. All we got to do now is to conclude bilateral arrangements with countries where we don't have those arrangements currently, and we didn't have them historically.
Now, I know we focused on the business community, but I want to, for the benefit of Guyanese, touch on an issue that I read in the Stavros News, and I thought that it was pretty interesting. It pertains to a case raised by economist Thomas B. Singh. And he spoke about the courts having a bit of exercising some extent of mercy, if you will, on pleadings that may be imperfect, where fraudulent conveyances are concerned. What is your perspective on that, on imperfect pleadings?
Again, this is a very fertile issue to speak on. And I have a lot to say. I just looked at the watch. I have a court matter. But let me deal with it. It's very, very important. And Mr. Singh must be complimented for raising this issue in the public domain. Others have done it. And we have responded to this on many occasions.
Okay.
So, now, we have had fraud being perpetrated against people's properties for decades. It's not a new problem. I am acutely aware of it, having been in private practice and seen it firsthand. And there are many reasons why it is happening. And we have addressed most of those reasons. First of all, we made it very clear to the deeds registry and the land registry, the two registries that are responsible legally for the transfer of properties, the conveyance of properties, that any corruption found in those agencies must be detected, and once detected, reported to the police with firm instructions to institute charges once the investigation yields the appropriate evidence to move in that direction. If not, once you find culpability, even if the police decides that they don't have enough evidence to charge, dismiss the person implicated, right? Because a lot of these things involve the collusion of members of the staff of these agencies. And over the years, we have rooted out a number of these persons. That's the first thing. So the first thing is to recognize the problem, which we have done a long time ago. At least I publicly recognize the problem as part of our government when I was Attorney General between 2011 to 2015. Since then, I've been speaking about it. Now, a lot of these frauds take place without the owners knowing, because the owners do not have access to an instrument called the Official Gazette. When a property is owned by transport, before it can be transferred from one owner to the next, and a publication to that effect is done in the Official Gazette. And if a person, for whatever reason, believes that that transfer should not take place, they have a right to oppose. And once they oppose, that transfer is put on hold. And then they have to file an action in the court to say why I'm putting this thing on hold. So if Kiana Wilborg is at home one day and she goes into the Official Gazette and then she sees that her property is being transferred to Mary Jane and realizes that she had nothing to do with this, is obviously a fraud. Somebody is pretending to be you. So you can stop it. The issue then was people do not have access to the Official Gazette, in particular in the rural areas of our country, and more peculiarly in the diaspora. A lot of the victims of this fraud, or these frauds, reside in the diaspora, right? So how do we solve that problem? We piloted a bill under my hand in the Parliament called the Official Gazette Online Act, and that allowed us to put the Official Gazette legally online. I was talking about important policy without legislation. That is how you have to do it by legislation. So the Official Gazette since 2012 has been online. And there's a unit within the Attorney General Chambers that is responsible for keeping that thing online. So every week we put the Official Gazette online. As it is published hard copy, a copy. And the one online is equally as valid and legally efficacious as that one that is on paper. So we address that issue number one. Two, one of the other ways by which the fraud is manifested is that Kiana Wilborg sells Anil her property. Anil pays Kiana a deposit and signs an agreement to say that the balance Anil will pay in 3 months' time when the title will pass, right? However, after you don't receive my deposit, you go on and sell the property to Mary Jane. You collect another deposit from Mary Jane, and you pass it to Mary Jane, and poor Anil doesn't know. When Anil realizes the property gone to Mary Jane, I can't get it back, you jump on a plane and you go on to New York, or you disappear, right? Or you sell it 3 more times and then disappear. And you rob everybody in the process. You collect 10 deposits and you're gone. I have amended the law. We have amended the law, the Deeds Registry Act, to say that once an agreement is signed, it must be filed as of record at the Deeds Registry. And we put on an intended purchaser a burden to go to the Deeds Registry to see whether there is any previous agreements pending in relation to the property that you are about to purchase. Now, I can't spoon feed people. That is in the law. So if you go and sign agreements without going and check whether there is a pending agreement prior to you signing this one, and that will be stronger in time and be given a precedence in law, how you want me to help you? Right? So that is in place. Then we recognize that another way that this fraud is being committed is by the use of a power of attorney. Right? This thing was studied, you know. I've done a lot of thought, put a lot of thought in this process. Because as a practitioner, I have seen how these frauds are being committed. So we amended the Powers of Attorney Act to put a couple of important additional requirements in place. One, that if you want to appoint your cousin, your agent, the instrument is called a power of attorney, but people are calling the person the power of attorney. It's a principle that you, the person who's giving the power, and the person receiving the power is called the attorney, right? So you want to appoint somebody, your agent, by a power of attorney, you have to go firstly to a notary public. That's the first thing. Not a JP, a notary public. When you go there, you have to produce 2 ID cards, two different pictorial IDs. Because when we put one in the law, they're forging it. So you have to put 2. You have to show me your ID card and your passport, or your ID card and your driver's license. And the notary public must keep it as well, right? And the deeds registry, when it's going to be filed there, because the power of attorney got to be filed there,
Right.
they must not accept it for filing unless they see these 2 photographs. Why photographs? Because the man that you're going in front of, or the woman that you're going in front of, must look at you and look at the photograph and see that it's the same thing. You're not showing somebody else's passport or an ID card that has no picture in it, right? Now, people are complaining that they don't have 2 ID cards, 2 pictorial form of identification. But it is for their own good. We are doing this. Nobody wants to impose laws that are oppressive and onerous. We are putting this in place to protect you and your property. So with these mechanisms in place now, I am not saying that it is impossible to commit fraud anymore, but it is appreciably more difficult with these mechanisms in place, right? But people also have to be vigilant. You have to be checking on your property. There are cases where court orders are forged, right? Now, we have a series of offenses that are on the law books that can deal adequately and condignly with those serious infractions of the law. Perverting the course of justice, fraud, uttering forged documents, committing forgery are all offenses that come to mind. And that's a serious problem. I don't know what I can do about that or what the government can do about that. That's a judicial issue.
But can anything be
Right.
done regarding an imperfect pleading regarding?
No, let me
a
deal with
fraud
that.
case?
What Thomas Singh is not a lawyer. I don't think he is a lawyer. He said he used the word there was some imperfect pleading. It is not. I did the case. He was referring to a case called Todd and Price. Now, let me tell you what happened in Todd and Price quickly. Price owned a property in Queenstown. And someone, a third party, produced a power of attorney that they are duly appointed by Todd, by Price, to sell this property. They came to Todd. Marlene Todd is her name. Marlene went to the registry and checked out the validity of the power of attorney. That time we didn't have agreement, we didn't have provision in the law for pictorial representation of ID and so on. The power of attorney was verified at the registry to be valid and in force. Marlene bought the property from this person, who is acting on behalf of Price, sorry. She paid market value. Marlin's position was, there is no way that I suspected anything was wrong. When the sale was concluded and Marlin got the transport in her name, it was discovered that a fraudulent power of attorney was used and that Price had nothing to do with the sale, and Price never authorized the sale. Price lives in America, or lived in America at the time. The person who committed the fraud was charged, placed before the magistrate court, and pleaded guilty, and was jailed. But Marlin is left with the property. Price lost the property. Price sued Marlin. Marlin's story is to the court, I have committed no wrong. I paid, this woman came forward. She says that she is duly authorized to sell this property. She presents the instrument of her authorization. It does authorize her to sell the property in law. I checked at the registry. I verified the authenticity and validity of this instrument. And based upon my lawyer's advice, I proceeded to buy. I paid the money, the lady took the money, and I got the transport in my name. What wrong have I committed? So to do justice, the court could not have done an injustice to Marlin either. Because Marlin didn't do anything wrong, Marlin thought. And that's what the Caribbean Court of Justice ruled. I won in the High Court. I was sorry for Price, but Marlin also did not rob him. Marlin was not guilty of fraud. Marlin paid several $1 million at that time for the property. Right? But at the end of the day, Price lost his property. The one person who robbed him gone to jail, and that was all he got. So that's the case that he's talking about. It was not that fraud was not pleaded against Marlin Todd. Fraud was pleaded, but fraud was not proven against Marlin Todd. Right? I don't think he appreciates the distinction.
Understood.
Right?
Attorney General and Minister of Legal Affairs, Mr. Nandlall, you provided us with comprehensive insight into many issues, and I want to thank you for participating in today's discussion. And also, since today's discourse is airing on a Sunday, I want to extend Happy Diwali greetings to you and your family, and Happy Diwali greetings to our audience as well. Once again, thank you very much for participating.
Thank you very much for inviting me to be part of this discussion. I got an opportunity to speak on a number of important issues, and I hope that I've contributed to the clarification of these matters for the public's benefit, because that's the purpose of these engagements. And I want to also take this opportunity to extend Shubh Diwali greetings to all my Hindu brothers and sisters, but to the entire country, as Diwali is a national festival. I will be out there lighting diyas, and will visit a couple mandirs to observe this auspicious occasion. Thank you very much.
Thanks as well. To our audience, thank you as usual for tuning in. My name is Kiana Wilberg, and I will see you next week, same time, same place, for more discussions from thought leaders within our landscape. See you next time.
Thanks for watching Starting Point. Follow us on Spotify, YouTube, Facebook, Instagram, and LinkedIn for critical updates and exclusive content.